Всім доброго дня! Ми раді вітати вас на нашому вебінарі. І сьогодні у нас в гостях Сергій В'ячеславович Саяпін, професор Казахстанського інституту менеджменту, економіки та прогнозування. Сьогодні ми поговоримо про сучасні тенденції у міжнародному кримінальному праві. Також ви можете задавати свої питання у чаті під нашою трансляцією на YouTube-каналі. Можна задавати питання і англійською, і українською, тож не соромтеся. Сподіваюсь, вам сподобається. І передаю слово пану Сергію.
Добрий день, дуже дякую вам, Юлія. Добрий день, шановні пані та панове. Я дуже радий поспілкуватися з вами сьогодні. Ladies and gentlemen, with your permission, I will deliver the rest of my lecture in English, as this was the arrangement. Please do not hesitate to stop me if you come up with a question, if you think of something that you would like to ask at this very moment. And I will do my best to answer the question during the lecture, or else you can leave the questions to the end, as you please. I'm very glad to be able to talk to you today because I like Lviv. And I thank you very much for inviting me to talk to you. I thank you very much for arranging this talk. I had a chance to visit your beautiful city last year. I taught a course at the Ukrainian Catholic University, and hopefully I will have a chance to meet you sometime again in the future. The topic of our discussion today will be modern trends in international criminal law. And interestingly enough, international criminal law began in Ukraine or in connection with Ukraine. And certainly some of you know this better than I do. I suppose that some of you are acquainted with this book. Східно-західна вулиця Повернення до Львова, written by Philip Sands, an English barrister. His grandfather lived in Lviv, as did two of the main characters of this book. And if you have not read the book yet, let me suggest that you get it if there is an occasion, and spend some time reading this fascinating story. It's a story, among other things, about how international criminal law began. Not exactly in the city of Lviv, but in connection with two remarkable individuals who lived and studied in law in Lviv in the 20th century. And I will come back to the book and to these two individuals in a few moments. I would like to talk to you about three things today. First, we'll recall some of the main milestones in the development of international criminal law. In the second part, we'll say a few words about the International Criminal Court, as this court is the main international organ dealing with international criminal law worldwide. And in the third part, I would like to raise a few issues pertaining to international criminal law and Ukraine today. And thus, you see, it will be a true comeback to Lviv, because we'll start with Ukraine and more particularly with Lviv, and we'll finish with raising a few issues that pertain to the development of international criminal law in your country today. So, why does this book matter, and what is the story behind it? The story dates back to the Second World War, to the Holocaust, to all the horrors that this war brought about. As you know, after the Second World War, the Allied victorious powers, that is the United States, the United Kingdom, France, and the Soviet Union, decided to establish an international tribunal to try the high-ranking political and military officials of Nazi Germany. Of course, I mean the Nuremberg Tribunal. The tribunal was established actually exactly on this day in 1945. And the purpose of the tribunal was to try those responsible Nazi officials among the politicians and among top-ranking, high-ranking military officials who played their part in launching and waging the Second World War. The Nuremberg Tribunal was supposed to try them for three categories of crimes: war crimes, that is, criminal violations of the laws and customs of war; crimes against humanity; and crimes against peace. War crimes were criminal violations of the laws and customs of war. That is, deliberate attacks against civilians and civilian objects, the use of prohibited means and methods of warfare, the destruction of civilian objects that was not justified by military necessity, and other violations of the Hague regulations pertaining to warfare on land that were formulated in 1899 and then updated in 1907. In this sense, war crimes had already a solid foundation in international law, because there were the Hague regulations of 1899 and then of 1907. It was logical that criminal violations committed mostly by armed forces, but sometimes also by civilians, so the violations of those regulations were considered as war crimes, and so individuals committing such violations were liable to be punished in accordance with applicable criminal law. The second category of crimes that was supposed to be tried at Nuremberg was more problematic, though, because it was novel. I mean crimes against humanity. These crimes were acts that were committed on a massive scale against any civilian population. And of course, the first of such acts that had to be penalized was the Holocaust. However, there was an issue in terms of law that by the time the Nuremberg trial began, there was no convention in international law that was designed to protect civilian persons. The Fourth Geneva Convention for the Protection of Civilian Population in Time of War, you will recall, was adopted 4 years after the end of the war, in 1949. And in 1945, there was no such convention in place. But of course, such a massive crime as the Holocaust and other crimes perpetrated during the Second World War against civilians might not remain unpunished. And so lawyers had to find a way to penalize the culprits for such crimes. And this way was found due to the inventiveness of one of the main characters of this book. His name was Herr Schlauterpacht. He was a lawyer trained in Lviv, and subsequently he became one of the top names in international law in the 20th century. He became Sir Herr Schlauterpacht. He became a professor of international law in the United Kingdom, a judge at the International Court of Justice. But at the Nuremberg trial, his role was in devising the concept of crimes against humanity. It was remembered that 30 years earlier, in 1915, during the First World War, when crimes similar to the Holocaust were perpetrated against Armenians in the Ottoman Empire, several states issued a joint declaration that condemned those murders and persecutions of Armenians. And in that declaration, those crimes against Armenians were called crimes against the laws of humanity. And so Herr Lauterpacht came up with this idea that since there are laws of humanity, there can also be crimes against such laws. And consequently, crimes committed on a massive scale against civilian persons could be named crimes against humanity, and they might be punished by an international criminal tribunal such as the Nuremberg Tribunal. And this was done. The third category of crimes that was penalized at Nuremberg were the so-called crimes against peace. And this was really problematic. Crimes against peace were essentially about starting a war as such. In other words, the question was, is it lawful to penalize an individual for his or her role in launching a war against another state, as Germany did against some other states in the Second World War? Unlike with respect to war crimes and to crimes against humanity, there was no solid foundation in international law for crimes against peace. And practically until the last moment, until the enactment of the Nuremberg Charter, there were doubts about the legitimacy and legality of crimes against peace. But nonetheless, the idea that war as such must become criminal, especially because the Charter of the United Nations was already adopted, especially because war was already outlawed in accordance with the Charter of the United Nations. Because war was outlawed in the spirit of the UN Charter, it was decided that crimes against peace should also be within the jurisdiction of the Nuremberg Tribunal. And so this trial took place. The Nuremberg Tribunal penalized most of the defendants, and historically it was likely a right thing to do. I am saying this in such a cautious way because the Nuremberg Tribunal was criticized by contemporary international lawyers as well as by subsequent international lawyers. On the one hand, it was a right thing to punish the perpetrators of some of the gravest crimes committed in the 20th century. On the other hand, the Nuremberg Tribunal did not punish or did not even try all who might have been tried if it had been a fair trial. I mean, the Americans were not punished for nuclear bombings of Hiroshima and Nagasaki. I mean, the British were not tried for the bombardment of Dresden, for example. I mean, the Soviets were not tried for mass rapes of German women, or else for the deportation of entire peoples within the Soviet Union, although all of these crimes could have been technically covered by the definitions of war crimes, crimes against humanity, and of course, crimes against peace, given the role that the Soviet Union played in concluding the Molotov-Ribbentrop Pact with Germany. Therefore, the Nuremberg trial was important, but it was imperfect. And it was great that one remarkable graduate of the Lviv University, Herr Lauterpacht, played such a prominent role in producing the definition of of crimes against humanity. I saw there was a question in the chat. I will come back to this question in the third part of my presentation because I was going to talk about that. Thank you very much for it. I want to say a few words about the second main character in this book, another graduate of the University of Lviv, who was prominent in defining a fourth crime under international law, which has remained in international criminal law until now. And actually, unlike the three previous categories of crimes under international law, this fourth crime, its definition remained virtually unchanged up to this day. Of course, I mean the crime of genocide and its author, Raphael Lemkin, who also studied at the University of Lviv. By the way, he and Hersch Lauterpacht took the criminal law course from the same professor, according to Philip Sands. And it is remarkable how able teachers can influence their students. At least we can see this at the example of Hersch Lauterpacht and Raphael Lemkin. In 1944, Raphael Lemkin published a book in which he used the word genocide for the first time. The word genocide consists of two parts: a Greek word genos, the people, and a Latin word fedare, to kill. So in sum, the word genocide means the destruction of peoples or of a people. And by introducing this term, Raphael Lemkin wanted to put in place a crime that essentially was directed against a people as such, against national, ethnical, racial, or religious groups, whereby certain acts were committed with an intent to destroy such groups in whole or in part. Obviously, the crime of genocide could not have been included in the Nuremberg Charter, and it was not tried at Nuremberg as such. Like I said a few minutes ago, the Holocaust was covered by the definition of crimes against humanity at Nuremberg. Why is that? Because Raphael Lemkin was not yet able to initiate a convention on the crime of genocide and to bring the process of its adoption to the conclusion. This convention was adopted in 1948 after the conclusion of the Nuremberg trials. But once this convention was put in place, the crime of genocide immediately became a part of international criminal law, and it remains such a part until now. Thus, ladies and gentlemen, if you come across this fabulous book, please get it and read it. It's a very interesting story of the role that the city of Lviv played in educating two remarkable international lawyers of the 20th century who played such a prominent role in the development of international criminal law. So what happened after Nuremberg? After Nuremberg, there happened another international criminal trial at Tokyo that was designed to try the major war criminals from among the high-ranking Japanese military and political officials who in their turn played a role in launching and waging the Second World War in the Far East. The Tokyo Tribunal was criticized by some international lawyers, even more harshly than the Nuremberg Tribunal was. The problem with the Tokyo trial was that whereas the Nuremberg Tribunal was based on an international agreement, the Tokyo Tribunal was established by a proclamation by by a chief officer of American occupation forces. And so in that sense, the legal basis of the Tokyo Tribunal was weaker, was much weaker than that of the Nuremberg Tribunal. Be it as it may, that trial took place and it played its important role in the history of international criminal law. The Tokyo trial was also concerned with the same three categories of crimes under international law, that is, war crimes, crimes against humanity, and crimes against peace. And it can be said that soon after the conclusion of the Tokyo trial, there was a long pause in the history of international criminal law. Well, for the sake of fairness, it must be said that in Europe, there were several other trials that were conducted on the territory of Germany by the Allied occupation courts. And those trials were based on the so-called Control Council Law number 10, and they were called the Nuremberg follow-up trials. Well, they were called this way because they followed up on the experience of the first major Nuremberg trial. And those follow-up trials focused on several groups of defendants. There was a trial of the judges, a trial of doctors, a trial of industrialists, that is, of groups of German individuals of German professionals, let me put it this way, because those trials, like I said, they were focused on several professional groups for the role that those groups played in Nazi Germany before and during the Second World War. For instance, the judges played their part in the application of discriminatory Nuremberg laws on whose basis Jews were discriminated against and prosecuted. Doctors played their role in carrying out medical experimentations that were harmful to the lives and health of the victims. The industrialists played their part in financing the German war machine and in providing that machine with resources. And so after the conclusion of those trials, there was a long pause in international criminal justice. During several decades, here and there in different countries, there were just a few domestic criminal trials dealing with individual crimes under international law. For example, the Eichmann trial in Israel. You can look up information about this trial on the internet, or else read a very interesting book by Hannah Arendt. But with the exception of those several trials, there was nothing at the international level until the early 90s, more specifically until 1993, when the Security Council of the United Nations established the International Criminal Tribunal for the former Yugoslavia, and then in 1994, the UN Security Council established the International Criminal Tribunal for Rwanda. What happened? What could have been the reason for the reluctance in the international community to conduct international criminal trials? Well, the answer is simple. The reason was the Cold War. Soon after the conclusion of the Nuremberg and Tokyo trials, the former allies in the Second World War, that is, the West and the East, became enemies, and political realities prevented them from cooperating in prosecuting crimes of an international concern. And moreover, some of these states, some of the former allies in the Second World War, well, they were themselves involved in organizing and committing quite nasty crimes. for example, during the war in Vietnam or in connection with the Soviet invasion of Afghanistan. So simply international cooperation in the prosecution of such crimes was impossible until the 1990s, when the Soviet Union disintegrated and the Security Council of the United Nations became operational again, to some better extent, let me put it this way. And so thus we are moving from the first part of my presentation to the second part of my presentation. And I saw there was a second question that I'll also take up towards the end, because I see it relates to the third part of my talk. The second part of my presentation will be devoted to the International Criminal Court. During the decades following the Second World War, there was an idea to establish one single international criminal court that would deal with crimes of the international concern, such as the crime of genocide, crimes against humanity, war crimes, and the crime of aggression. You see that all those trials that I mentioned before, the Nuremberg trial, the Tokyo trial, or the two international criminal tribunals established by the UN Security Council for the former Yugoslavia and for Rwanda, all those tribunals and trials focused on specific conflicts, and their jurisdiction was limited to specific states or to specific geographical regions. And the idea was that all those tribunals would stop operating after they try all the cases that they're entrusted with. And actually it happened so. And so the idea was to establish a permanent international criminal court that would operate on a more permanent basis, that would have a more far-reaching jurisdiction, that would be able to try people who would be engaged in the commission of such dangerous crimes in the future, well, ideally, wherever they're committed in the world. Ideally, the International Criminal Court should have become a universal court. As we shall see in a few moments, this is not yet the case, but the idea was certainly beautiful. The idea was to learn from the lessons of Nuremberg, Tokyo, Yugoslavia, Rwanda, of those domestic criminal trials dealing with international crimes, and to establish one organ of international criminal justice that would be able to try individuals for the gravest crimes of international concern, irrespective of the power and influence of those individuals. So, the International Criminal Court was established in 2002. Its statute was adopted in Rome in July 1998, and it took states almost 4 years to bring the statute into effect. And the Rome Statute of the International Criminal Court was established in 2002. Now, the Rome Statute of the ICC, of the International Criminal Court, has 123 states parties, and the jurisdiction of the ICC includes 4 crimes under international law that we already know about. That is the crime of genocide, crimes against humanity, war crimes, and the crime of aggression. The jurisdiction of the International Criminal Court is based on 2 main principles. First is the principle of territorial jurisdiction, that is, the ICC can try people who commit those crimes on the territories of states that have ratified the Rome Statute of the International Criminal Court. The second jurisdictional principle of the ICC is the so-called active personality principle. It means that the court has jurisdiction with respect to crimes committed by the nationals of those 123 states that have ratified the Rome Statute. You see, the drafters of the Rome Statute consciously rejected the principle of universal jurisdiction. They took a conscious decision not to give the International Criminal Court the power to prosecute individuals for the crimes of genocide, crimes against humanity, war crimes, and the crimes of aggression, wherever they may be committed in the world. The proponents of universal jurisdiction could say, well, why actually not empower the ICC to prosecute people wherever they may be in the world and wherever they might commit their crimes? Because this is the International Criminal Court at the end. But the authors of the Rome Statute decided otherwise. They took a pragmatic decision. They understood that if the ICC had been given universal jurisdiction, quite soon it would be overwhelmed with cases coming from different parts of the world, because unfortunately, crimes under international law continue being committed in many different countries. And so instead, the International Criminal Court is based on the principle of complementarity. It means that the states parties to the Rome Statute have jurisdiction with respect to those crimes in accordance with their domestic criminal laws, and only if the states parties are not willing or not able to prosecute individuals committing such crimes themselves, only then will the ICC exercise its criminal jurisdiction with respect to such individuals on the basis of the territorial principle or the principle of active personality. So as you see, the decision was practical. The decision was to responsibilize states, to let states do their job of prosecuting individuals who commit atrocious crimes on their territories or being the nationals of the states concerned. But there emerged another problem, which in the end, I would say, made the International Criminal Court exposed to criticism. The problem was that, at least in the first years of its operation, the International Criminal Court focused on situations exclusively, not just mostly, but exclusively in African countries. And this made some African countries upset. While the International Criminal Court was being established, while the Rome Statute was being written, African states were very enthusiastic about the ICC. They were very supportive towards the ICC. And they were hoping that the International Criminal Court would help them resolve some of the pressing problems that they were experiencing. And it is a fact that many African states are witnessing crimes of interest to the International Criminal Court. But the fact that the ICC prosecutor exclusively focused on African states during the first years of the ICC operation, well, led some African states to change their opinion about the International Criminal Court. And what was done in 2014 was interesting. In 2014, the African Union and you know this is a regional organization for African states, they adopted the so-called Malabo Protocol, establishing an alternative to the International Criminal Court sometime in the future, and I personally hope it will enter into force in the future, because I like very much the spirit of the Malabo Protocol. So the idea is to establish a regional African court having jurisdiction with respect to crimes under international law. And so when the Malabo Protocol enters into force, well, it's very likely that the African regional court will be trying crimes under international law committed on the African continent instead of the International Criminal Court. And thus, you see the International Criminal Court, although it was established based on the experience of previous trials, although lessons from previous trials were learned, still the ICC is imperfect, and still there are developments in international criminal law which could potentially lead to weakening the International Criminal Court in the future. Let us wait and see. And now I am entering the third part of my presentation, that is international criminal law and Ukraine. And thus I'm hoping to close the circle. I began my presentation with Ukraine, and I'm ending it with Ukraine. What is the importance of international criminal law for Ukraine now? I'd say it is immense for quite obvious reasons. And now I'm opening the chat with your questions. And very soon I will come to the first question in the chat. Unfortunately, international criminal law became very topical and important for Ukraine in 2014, when Russia committed aggression against Ukraine. And soon after that aggression began, academic circles and politicians in Ukraine understood maybe understood is not the right word, but let me say, thought again about the significance of international criminal law. Because why do I mean that understanding might not be the right word here? We all understand that international criminal law is important. We all understand that genocide, war crimes, crimes against humanity, and the crime of aggression must be prosecuted and penalized. But we do not really think that such crimes can ever concern us or our country until it really happens. I know this from my prior experience of working at the International Committee of the Red Cross. During my work at the ICRC, and we pursued dialogue with the national authorities of many states, and when we talked to them about international humanitarian law, oftentimes we would hear in response polite words like, yes, we understand you, yes, the Geneva Conventions are important, but how do they concern us? We are peaceful countries. And unfortunately, it is a fact that states and people come to realize the significance of international humanitarian and criminal law when there begins an armed conflict. And so almost immediately, international criminal law became important and significant in Ukraine in 2014 and since 2014. And now let me take up the first question. Is it possible to bring charges against those responsible for the aggression in the east of Ukraine? What are the possible ways of tackling the problem that has occurred? Actually, Ukraine has already played a prominent role in trying individuals for the crime of aggression. And some of you may know about this. As a matter of fact, Ukraine already is the first state in the world that tried someone for the crime of aggression since the conclusion of those follow-up Nuremberg trials that I mentioned earlier. Of course, I mean 2 trials that took place in Ukraine on charges of aggression. And the first trial was against 2 Russian military servicemen, Alexandrov and Yerofeev, who in the end were exchanged for Nadia Savchenko in order for her to come back to Ukraine. Some of you may recall what that trial was about. Those 2 men served in Russia's armed forces. They were sent to the east of Ukraine to fight in the armed conflict. They were apprehended and charged in Ukraine with crossing the border illegally, with carrying out terrorist activities, and with conducting aggressive hostilities against Ukraine. Article 437 of Ukraine's criminal code permits the criminal prosecution on charges of aggression, not only of a state's supreme or high-ranking officials, like it was done in Nuremberg, but also of, well, basically of any individual. This is the difference between Ukraine's criminal codes, its Article 437, and customary international law on the prosecution of aggression. Customary international law tells us that aggression is a so-called leadership crime, that one has to be a leader of a state, a political, military, religious, or social leader in order to be able to commit the crime of aggression. But Article 437 of Ukraine's criminal code tells us that aggression can be committed by anyone. A war of aggression can be launched only by a supreme state official, but aggressive hostilities can be conducted by lower ranking people like Alexandrov and Yerofeev. And I think personally it's a right approach, because it helps a state well, better protect its national security. So there was that trial in Ukraine. There was also another remarkable trial in Ukraine. And of course, I mean the trial of the former president, Viktor Yanukovych, who was charged with aggression and who was convicted for it. Remarkably, Yanukovych is the second former head of state in the whole world who was ever convicted for aggression. The first former head of state was Karl Dönitz. He was convicted by the Nuremberg tribunal, and Yanukovych was the second. Moreover, Yanukovych was the first former head of state ever who was convicted for facilitating the commission of aggression against his own country. That was the essential difference between his conviction and the conviction of Karl Dönitz. Dönitz was found guilty of aggressions committed against other states, whereas Yanukovych was tried and convicted for facilitating an act of aggression against his own country. So in that sense, Ukraine already played a prominent role in reviving the crime of aggression from its dormancy or sleep that lasted for decades. And I hope that Ukrainian judges and law enforcement officials will learn from this experience of prosecuting individuals for international crimes, and they will be an international criminal law will become a part of professional culture of judges and law enforcement officials in Ukraine. Regarding another aspect of your question, is it possible to bring charges against those responsible for aggression in the east of Ukraine? Well, the answer is yes. It is possible to bring charges against other individuals who were involved in committing that aggression. Well, first of all, against officials of the Russian Federation. But from a practical point of view, the enforcement of such charges will be more difficult, because it will be somewhat more difficult, at least in the near future, to actually get those individuals for trial. And so I think a more practical way for Ukraine would be to continue enforcing the crime of aggression consistently when it has opportunities to prosecute people whenever Ukraine gets hold of them. It may not be the supreme officials of other states. It may be lower ranking people. But by enforcing international criminal law consistently, Ukraine will show to other states that it takes international criminal law seriously, and that that it cares about protecting its interests through legal ways. Let me take up the next questions. Яких професій повинні бути депутати? Well, that's a good question. And what must be the professions of members of parliament? I'd say you'd better address this question to constitutional law specialists. But I will say what I think about this, because essentially this question is rather about constitutional law. And I am an international criminal law specialist, so my answer might be limited to some extent. I think that members of parliament, well, they should be professional politicians. Let me put it this way. In the sense that they must understand what politics is about and how politics works, how laws are made, what legal technique is, what the political priorities are. Members of parliament should have the necessary general and professional culture for it. And I am not exactly sure that people of, let's say, non-political professions such as artists or actors, they would be immediately prepared for political action if they are elected into parliament. But if this happens, I'd say there must be some training for new members of parliament about issues of law and about issues of politics, about the technicalities of parliamentary work, so that they might be better prepared for legislative work. Let me put it this way, because well, both politics and law are important and should not be taken lightly. There must be some professional preparation for people who adopt laws and thus influence entire peoples. The next question is about mistakes and right steps in the situation of 2008 with Georgia. Let me put it this way. I think Georgia was right to initiate a legal case against the Russian Federation at the International Court of Justice. That was definitely a right step. In military terms, Georgia could not possibly compete with Russia. Russia is an important military power, and that's a fact. So because Georgia could not compete with Russia in military terms, it opted for a different way. It opted for exposing the illegality of Russian conduct in terms of international law, and brought the case to the International Court of Justice. I think it was a right thing to do, because military force is important, but it does not decide everything in today's world. Military power was more decisive in the past. Now, other factors are more important, such as economy, such as culture, such as the international image, such as respect for human rights and fundamental freedoms, and other non-military factors. So Georgia was very right in challenging the Russian Federation in the on the legal plane, and in that sense, Ukraine was correct in bringing a few cases against the Russian Federation as far as the law of the sea is concerned, as far as human rights law, especially European human rights law, is concerned, and of course, I mean the two ongoing cases at the International Court of Justice, one concerning racial discrimination in Crimea, and the other one concerning the financing of terrorism in eastern Ukraine. In this sense, Ukraine is, I think, learned good lessons from Georgia's experiences and started challenging Russia at various international judicial fora. And what's good, Ukraine started winning some of those arbitral litigations, and hopefully will win more cases in the next years, and thus international law will gradually prevail over military power, and that's definitely good, because law is an element of civilization. Thank you for your lecture. Thank you very much for being here. Could you please dwell upon what are the biggest current challenges that international criminal law must face now? What are the ways to resolve it? Well, challenges are many. Challenges are both, well, they are legal, political, and organizational. Regarding legal challenges, one challenge is to continue integrating international criminal law into the domestic laws of states. you will remember that the International Criminal Court is based on the principle of complementarity. And it means that the ICC will only look into situations where crimes within its jurisdiction were possibly committed only if the state or the states concerned are not willing or not able to prosecute for the commission of such crimes themselves. It means that the main responsibility for the prosecution of such crimes is with the states. In the case of Ukraine, the International Criminal Court is now considering the situation in Ukraine in the context of the ongoing armed conflict with Russia in the east of the country and of the occupation of Crimea. But this consideration takes time, it takes resources, and Ukraine should do some homework itself in order to help the ICC on the one hand, but also in order to help itself, in order to reinforce itself. And I'm pleased to know that the Parliament of Ukraine is considering amendments to Ukraine's criminal code that, when adopted, will bring some of the provisions of Ukraine's criminal code in line and in conformity with the Rome Statute of the International Criminal Court. So, because states must themselves be prepared to prosecute individuals for crimes under international law, and Ukraine, although it's already doing this, can do it even better if it improves its domestic criminal legislation in line with the Rome Statute of the International Criminal Court. The political challenges, well, I mentioned one of them. One of them concerns the acceptability of the International Criminal Court. Remember the example of the African Union. At the beginning, African states were very supportive towards the ICC. But then when the ICC prosecutor started focusing exclusively on situations in African countries, some African countries were not happy about that, and some of them even went as far as to call the ICC a racist court. And the African Union came up with this alternative of the Malabo Protocol. The ICC should make itself acceptable to states of different political systems and of different legal traditions. One of the biggest political challenges to the ICC is the opposition against the ICC of some powerful states, such as the United States of America, Russia, India, China, Israel, who, for various reasons, do not want to ratify the Rome Statute of the International Criminal Court. And you may agree that without the participation of such big and populated and influential global and regional powers, the International Criminal Court is considerably weakened. Another factor that plays a role in the acceptability of the International Criminal Court has to do with religion, or rather, more specifically, with religious law. If you look at the list of states parties to the Rome Statute, you will notice that quite many major Islamic states do not participate in the activities of the International Criminal Court. You can ask yourselves why that is the case. And the answer is that the International Criminal Court, the law of the International Criminal Court, is mostly based on the Anglo-Saxon and continental legal systems, and takes the Islamic international criminal law into account to a much lesser extent. And if you think about it, there is Islamic international criminal law. There is a rich legal tradition of defining and prosecuting international crimes based on Islamic religious law. But unfortunately, this factor was disregarded in the drafting of the ICC statute, and therefore a big part of the world is now left out of the ICC operation. So to sum up, challenges to international criminal law, to its implementation and enforcement, are international and domestic. They're legal, political, and organizational. They are big and small, and gradually, as many of them as possible should be overcome. And I hope that Ukraine will be learning from its own experience, from the experience of other states, and will gradually improve its domestic legislation as far as international criminal law is concerned, will train its judges on and law enforcement officials on international criminal law, will cooperate with other states, and in the end, the quality of understanding and enforcing international criminal law in Ukraine will improve. And let me take the final question, and then I guess we might conclude the session, as we will soon be running out of time. To what point the concept of human dignity and the rule of law are core to international criminal law? Rights? Well, the concepts of human dignity and rule of law, well, they are key in international criminal law, because as you may already understand, much of international criminal law is based on international humanitarian law as far as war crimes are concerned. War crimes are criminal violations of international humanitarian law, and in that branch of public international law, the concept of human dignity is key. All humanitarian law is about protecting specific categories of persons, such as the wounded, sick, shipwrecked, prisoners of war, civilians, and specific categories of civilians in situations of armed conflicts from dangers of arising in such conflicts. And because humanitarian law is based on the concept of human dignity, by analogy, the concept of human dignity is crucial for the concept of war crimes, which are one category of crimes under international law. If you think of crimes against humanity, well, you will see that they are based, this concept is based on international human rights law, basically. Crimes against humanity are widespread or systematic violations of fundamental human rights, such as the right to life, the prohibition of torture, and other fundamental human rights and freedoms. Because international human rights law is aimed at protecting human dignity, by analogy, international criminal law, which criminalizes crimes against humanity, also is focused on protecting the dignity of people, of persons affected by armed conflicts and by other situations of violence. Simply, well, in other words, international humanitarian law, international criminal law, and international human rights law, although formally they are distinct branches of international law, but still they have the common aim of protecting human dignity, and they work together. The next question: what rights does an international lawyer enjoy? What service organizations are created to search for criminals at the international level? Is it possible to get into these teams with our education? The question is big, and but I'll try to go to the point. International lawyers have, well, they do have rights as participants of international criminal trials, as prosecution attorneys, as defense attorneys, and in order to see the specific rights that international lawyers enjoy in different international, well, interstate or especially international criminal trials, you have to look into the rules of procedure of specific courts. For instance, you have to look into the rules of procedure of the International Criminal Court, or else of other so-called hybrid tribunals that operate in different parts of the world and deal with international criminal law. In any case, the rights of international criminal lawyers will be concerned with the concept of fair trial. International criminal lawyers will be given rights, on the one hand, to serve the interests of their clients, and on the other hand, to serve the interests of justice. These rights will be aimed at ensuring their independence that would be sufficient for them to perform their functions, and on the other hand, their rights would be limited by the interests of justice. For instance, international criminal lawyers would not be allowed to fake evidence in the interest of their client, even if faking evidence might be useful to protect the interests of a lawyer's client. It would certainly be disallowed by the applicable law because it's unlawful and unethical. And which organizations are created to search for criminals at the international level? Well, first of all, it's Interpol, the International Organization of Criminal Police, which is headquartered in Lyon, in France. And this organization is there to enable cooperation between its member states' police services at the international level in the apprehension and surrender of alleged criminals who are sought by the Interpol member states. And of course, states cooperate with each other bilaterally in searching for persons who are wanted for prosecution and in enforcing penal judgments. Is it possible to get into these teams without education? Well, I'd suggest that if you want to specialize in international criminal law, you should obtain a master's, at least a master's degree in international criminal law. There are good LLM programs at various universities that offer quality education in international humanitarian, human rights, and international criminal law. You could think, for instance, of the University of Essex in the United Kingdom. You could think of the Ruhr-Universität Bochum in Germany. You could think of the European University Institute in Italy. You could think of the University of Nottingham, again in the United Kingdom. An LLM program is basically key. It's key if you want to build a career in international criminal law, because it will help you specialize in these fairly demanding, fairly challenging areas of law, on the basis of your bachelor education. A bachelor degree in law would enable you to work at various organizations. You could work for the state, you could work in private practice, you could work at an international organization, but an LLM degree would help you become a specialist within an area of law that will make you internationally competitive. So that's my advice. And finally, how does international criminal law deal with the issues which is so much connected with foreign policy? Do you think there are some ways to make it more apolitical? It's a difficult question. Law is by definition a political phenomenon. Let's make it clear, or else if you disagree with me, give me arguments if you disagree. But law is always political. There was a famous American international lawyer, Professor Louis Henkin, who said something like, international law is political because law is made by political actors through political processes for political ends. And that's it. This is probably one of the biggest truths about law. Law is made by politicians according to the priorities of the time, according to their understanding of the right and wrong. Law is made by political institutions. Parliaments are political institutions. International organizations and organs of international organizations, such as the United Nations Security Council, are political bodies. And the members in all these organs, they do what they do on the basis of their political interests. That's a reality, and this reality must be accepted. However, if we talk about ways to overcome possible foreign policy obstacles to the ideals of law, well, there are such ways. You as international lawyers, and we all as international lawyers, we have to talk to politicians. We have to try to make politicians understand that we are useful to them. Yes, I see we need to finish us up, and this will be my answer to the last question. We need to talk to politicians and convince them that politics needs to serve the interests of the people and the interests of society. We need to convince them that it is in the interest of our people, our state, and of the world as a whole to make good laws. And we need to train our judges so that judges know what international criminal law is about, and so that they make right decisions on the basis and with due regard to international criminal law. It takes time, but it's possible. And maybe to make it possible, we should start integrating the ideas of international law and justice in the minds of future politicians, that is, of students like you. And this could be an excellent point to end our discussion, because very soon, many of you, after graduation, will go to work at various state organs. You will be advisors to ministries, to the parliament. You will become assistant judges, and you will help judges draft decisions. And if you know already as senior students what international criminal law is about, then you will apply this knowledge and these skills in your future professional activities. And so it's a right thing to do what we are doing now, that is to study international criminal law already while you are students, so that you think about it and you make international criminal law a part of your professional culture that you will apply in the future. With your permission, at this I will end, and I will thank you very much for your attention. Thank you very much. It was my pleasure to talk to you.
Пане Сергію, від імені Львівського осередку хочу дуже сильно вам подякувати за таку круту лекцію. Було дуже інформативно і цікаво, і ми будемо дуже раді бачити вас вже на наших наступних заходах. Надіємося, приїдете до свого улюбленого Львова, і ми з вами зустрінемось.
Дуже дякую і сподіваюся, до побачення.
Так, до побачення.
Побачення.